I'm Cynthia Rowland, and this is episode 102 of EO Radio Show. Today's episode is the third in a series of several critical compliance topics relevant to international grant-making by U.S. public charities and private foundations. These three rules are anti-terrorism rules, income tax withholding rules, and some special rules for private foundations. All U.S. charitable organizations that make grants to organizations or individuals not resident in the United States need to be aware of a couple of general requirements, and private foundations have an extra set of concerns. In order to be sure that the expenditure by the private foundation outside the United States is not penalized as a taxable expenditure, and that it does count toward the foundation's minimum distribution requirement. In the first episode of this little series, I focused on the Patriot Act rules that apply to all grants, international and domestic. In the second episode, I provided a brief overview of the income tax withholding rules that apply to payments for services and which come into play when making a grant to an international organization that provides some services in the United States. This third installment of the series will focus specifically on the special private foundation rules, expenditure responsibility and equivalency determination, and I'll touch on the penalties when there is a footfall or a problem with the international grant. Welcome to the EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. In this part 3 of the series on international grant making, I'm going to talk about the private foundation rules. Private foundations can distribute funds to foreign organizations to conduct activities outside of the United States, but must follow special rules when dealing with the foreign organization in order to avoid the excise taxes under Internal Revenue Code sections 4942 and section 4945. Be sure to check out the show notes for further resources, including the revenue procedure that I will be talking about, including the expenditure responsibility rules. Private foundations may wish to treat their grants to foreign grantees as qualifying distributions that satisfy the distribution requirements imposed by the tax rules and not as expenditures requiring expenditure responsibility. When private foundations make grants to foreign organizations, there are 4 common scenarios, 3 that are not a problem and 1 that is. The first scenario is where the foreign organization actually has been recognized by the Internal Revenue Service as a Section 501c3 public charity. This category is often met because foreign organizations that fundraise in the United States know that it's a hassle for private foundations, so they can seek their own determination letter. And that's great. If that's the case, if your foreign grantee actually has been recognized as a public charity by the IRS, that solves a lot of the foundation problems. The second scenario is where a private foundation that is the grantor receives and can rely on an equivalency determination that the foreign organization is equivalent to a Section 501c3 public charity under U.S. laws. The third scenario is where the grantor private foundation specifically limits the use of the grant to Section 170C2B purposes, that's general charitable purposes, and most importantly, maintains expenditure responsibility for the foreign grant payments. And the fourth scenario is the one that comes up for private foundations in the U.S. that aren't aware of these rules, and the grant actually constitutes a taxable expenditure and is not a qualifying distribution. That's a really bad outcome. So that's the whole point of this episode, is to educate private foundation grantors so that they have a general understanding of these rules when making grants to foreign organizations. So let's look at the details for the first 2 situations. First, the foreign organization actually has an IRS determination letter. Foreign organizations can apply to the IRS and receive a determination letter as a recognized exempt organization under U.S. law. If the IRS determines that the foreign organization is a 501c3 public charity, then any grants from a private foundation to the foreign organization for charitable purposes will generally be treated as a qualifying distribution. The private foundation does have to substantiate the foreign organization's exempt status by having in its files a copy of the IRS determination letter, or has actually checked the IRS database for the current exempt status of the organization. For Section 4945 purposes, a public charity isn't all public charities, it's a subset. For 4945 purposes, that is the taxable expenditure rules, the organization is treated as a public charity only if it's described as a public charity under 509A 1, 2, or 3, other than certain types of supporting organizations, or it's an exempt operating foundation. Now, these are very technical rules, so it's important to look at the fine print. And the allowable charitable purposes under 170C2B are the following general charitable purposes, which sound familiar to most foundation grantors. And that is religious, charitable, scientific, literary, or educational purposes, but only if no part of the activity involves the provision of athletic facilities or equipment. And it also, the allowable qualifying charitable purposes for these rules also includes national or international amateur sports competition or the prevention of cruelty to children or animals. So nothing terribly surprising there, but it is a technical requirement to make sure that the foreign organization's charitable purposes fit within this subset. So let's talk a little bit about an equivalency determination. What does that mean? So we've got our foreign grantee doesn't have an IRS determination letter, but we don't want to exercise expenditure responsibility. So what is involved in obtaining an equivalency determination? If the foreign organization hasn't received the IRS determination letter, the rules are more complicated under the equivalency determination procedures. Generally, these rules require that the private foundation make a good faith determination that the foreign organization does meet the qualifications for public charity rules. This good faith determination is described in detail in Revenue Procedure 2017-53, and I'll have a link to that in the show notes. So let's talk specifically about the equivalency determination requirements. A private foundation grantor that wishes to have the grant to the foreign organization grantee, who treated as a distribution to a qualifying public charity, has to follow two general steps in making the equivalency determination. First, the grantor foundation, through one or more foundation managers, must make a good faith determination and a reasonable judgment that the grantee actually is a charitable organization. And second, the grantor has to make a good faith determination that the grantee is publicly supported. So let's talk a little bit about these general requirements. First, what is a charity under these rules? As I alluded to a minute ago, this is the determination that the foreign organization is organized and operated in a way that meets the general requirements of Internal Revenue Code Section 501c3. And then the grant has to be made actually for a qualifying charitable purpose. And that the grant also, it can't be a transfer of assets pursuant to the liquidation, merger, redemption, recapitalization, or other adjustment of the grantor foundation. So these are relatively technical rules. Be sure to check the RevProc to make sure you can check the box on all of those. Second part of this general equivalency determination is that the determination has to be made that it is a publicly supported charity. Again, these are the technical rules that describe whether a charitable organization is a private foundation subject to much more stringent rules or a publicly supported entity. And for links to prior episodes that talked about the distinction, be sure to check the show notes for that. So let's talk about what this means for equivalency determination purposes. The applicable Treasury regulations provide a general rule that a private foundation grantor may treat the foreign grantee as a qualifying publicly supported charity if the foundation has made a good faith determination to that effect. The regulations include a special rule that a private foundation's determination ordinarily will be considered made in good faith if it's based on written advice that is current and received from a qualified tax practitioner who concludes that the grantee is a qualifying public charity, and furthermore, that the foundation reasonably relied in good faith on that written advice. There's a special rule that says what written advice qualifies. The written advice must include sufficient facts concerning the foreign grantee's operations and support to enable the IRS to determine from reading that written advice that the grantee would likely qualify as a public charity as of the date that the written advice is given. So let's break down these technical requirements and look at the 6 important parts of this rule. The first part of this technical requirement for equivalency determination is that the written advice has to be current. For purposes of this special rule, Written advice is generally current if the relevant law on which the advice is based has not changed since the date of the written advice, and the factual information on which the advice is based is from the grantee's current or prior taxable year or the current or prior annual accounting period if the grantee doesn't use a taxable year for U.S. federal tax purposes. Thus, a grantor can rely on written advice for a period of up to 2 years after the advice is provided, depending on when within the grantee's taxable year the advice was provided and how recent the factual information is on which the advice was based. So in other words, you don't necessarily have to get a written opinion that meets all these criteria every single year that you make a grant, but you can't use it for very long, and you have to be sure that it's still treated as current. So the second of these 6 special criteria we want to talk about is what is a qualified tax practitioner for purposes of the written advice. A qualified tax practitioner is an attorney, a CPA, or an enrolled agent, that is an agent that's enrolled with the IRS, who is subject to the standards of practice before the IRS that's set forth in particular rules under the published by the IRS known as Circular 230. To practice before the IRS, this Circular 230 requires that the attorney or CPA be licensed in a state, territory, or possession of the U.S. And for purposes of an enrolled agent, that enrolled agent who doesn't have to be an attorney or a CPA, but they have to meet these eligible requirements that are set forth in this circular. So that's part 2 of 6. Part 3, what does it mean to be a qualifying public charity for these purposes? 501c3 organizations are classified as public charities or private foundations under Internal Revenue Code Section 509A. By way of background, public charities under 509A include, but aren't limited to the following ones, but these are the most common: churches, schools and universities, hospitals, publicly supported organizations that have broad general public support, certain kinds of supporting organizations. There are a number of different kinds of supporting organizations under 509A, but not all of them can be used for an equivalency determination. A disqualified supporting organization that meets the requirements of 509A but can't be included for purposes of an equivalency determination are certain kinds of non-functionally integrated Type 3 supporting organizations. A disqualified supporting organization also includes other supporting organizations if certain persons that are involved with the private foundation grantor directly or indirectly control the supporting organization, and there's some other technical rules. So just a red flag that if your grantee is a supporting org, you'll need to have your qualified tax practitioner look very closely at these rules. So the fourth general area of 6 that we're going to talk about here for our equivalency determination is the meaning of reasonable reliance. Under these rules, all pertinent facts and circumstances must be taken into account in determining whether a private foundation has reasonably relied in good faith on the written advice from the qualified tax practitioner. The things that need to be taken into account are the foundation manager's education, sophistication, and business experience. This standard is not met if the private foundation knows or reasonably should know that the qualified tax practitioner lacks knowledge of U.S. tax law about charities. Moreover, a private foundation may not rely on the written advice if it knows or has reason to know that relevant facts were not disclosed to the qualified tax practitioner, or that the written advice is based on a representation or assumption that the foundation knows or has reason to know is unlikely to be true. So the 5th category of the 6 we're talking about here for our equivalency determination are the general requirements that are imposed on the qualified tax practitioner in preparing the written advice. The qualified tax practitioner has to base their written advice on reasonable factual and legal assumptions, including assumptions as to future events. They must reasonably consider all relevant facts and circumstances that the practitioner knows or reasonably should know. They must use reasonable efforts to identify and ascertain the relevant facts. They can't rely on representations, statements, findings, or agreements of the taxpayer or any other person if reliance on that would be unreasonable, which is the case if the practitioner knows or reasonably should know that these representations or assumptions are not accurate. The qualified tax practitioner also needs to include in this written advice, they have to include the applicable law and authorities that relate to the facts, and usually this refers to both U.S. and foreign laws. And the written advice, the qualified tax practitioner in preparing the written advice cannot base the advice on consideration of a possibility that the return will not be audited or that the matter will not be raised by the IRS on audit. The qualified tax practitioner also needs to rely in good faith on the information furnished by the grantee and can't ignore the implication of information furnished to it or actually known by the practitioner. And they must make reasonable inquiries if the information as furnished appears to be incorrect, inconsistent with an important fact, or another factual assumption, or appears to be incomplete. Also, under these rules, a qualified tax practitioner can rely on the advice of another person, such as foreign counsel, on a question of foreign law, if that advice was reasonable and the reliance is in good faith, considering all the facts and circumstances. Reliance is not reasonable when the practitioner knows or reasonably should know that the opinion of the other person should not be relied on, the other person isn't competent or lacks the necessary qualifications, or the other person has a conflict of interest. The sixth of these areas that are really important for the quality of the equivalency determination are the facts that are relied on. The equivalency determination regulations require that the written advice must include enough facts about the matter concerning the foreign grantee's operations and their financial support in order to enable the IRS to determine that the grantee would likely qualify as a qualifying public charity as of the date of the written advice, and include a conclusion that the grantee is a qualifying public charity for purposes of the relevant sections of the Treasury regulations. Now, there are many more specific rules in Rev Proc 2017-53. For example, the attachments to the written advice must be in English. There are certain rules about reliance on translations of foreign laws, the sufficiency of the facts, and so forth. The bottom line is, an equivalency determination is a legal opinion letter under U.S. law that has to be considered to be something that would be given over to the IRS if the IRS asks for it on audit. These equivalency determinations tend to be very expensive and very time-consuming to gather the facts and to get the written advice that you need. So they often make sense only for a very large grant. Now, there are some services in the U.S. that do equivalency determinations and operate somewhat like a donor-advised fund. I'll put a link to one or two of those in the show notes. And so organizations that want to make relatively small grants and where an actual equivalency determination makes no economic sense or is possible given the timeline, sometimes one of these facilitators can be a good answer for that. So moving on from equivalency determinations, suppose you can't gather an equivalency determination at a reasonable price or in a reasonable timeline, and you still want to make the grant and a facilitator is not going to solve the problem. So in that case, the expenditure responsibility rules can be used for that purpose. Expenditure responsibility generally means that the foundation exerts reasonable efforts and establishes adequate procedures to ensure that the grant is spent only for the purposes for which it is made, that the grantor obtains full and complete reports from the foreign grantee organization on how the funds are spent, and the grantor foundation has to make full and detailed reports on the expenditure to the IRS on the annual Form 990-PF for as long as that grant period is open. Prior episode of the EO radio show, episode 58, goes into detail on the expenditure responsibility requirements. So I won't repeat all of that here, but that is another avenue. It's also somewhat time-consuming, but not generally as expensive in terms of outside legal costs as compared to an equivalency determination. So a few quick notes on the fourth scenario that I talked about way at the beginning of the episode, which is the fourth thing that sometimes happens. If the foreign organization doesn't have a IRS determination letter, equivalency determination is not obtained, expenditure responsibility grant procedures aren't followed, but the grant was made. What then? Well, if the foreign organization isn't recognized as an exempt, as a 501c3, and we don't have equivalency determination and we didn't exercise expenditure responsibility, then the grant is a taxable expenditure. The taxes are imposed on both the foundation and on any foundation manager who knowingly and willfully agreed to the grant, knowing that it would be a taxable expenditure. There's both an initial tax and an additional tax under 4945 that can be imposed on the foundation grantor and on the foundation management. So what happens if you find out you've made a taxable expenditure, but you want to correct it? Because if you don't correct it, these additional taxes apply. In cases other than just simply inadequate reporting, a correction is accomplished by recovering part or all of the expenditure to the extent possible from the grantee. If full recovery of the amount is not possible, additional corrective action can be described by the IRS. Additional corrective action depends on the circumstances and could include withholding on unpaid funds that are still due to that particular grantee, stopping further grants to the grantee, providing periodic reports to the IRS from the foundation for all of its expenditures, or improving methods of exercising expenditure responsibility in general, and any other action that the service can prescribe in the particular case. Now, a footnote here, if the problem with the foreign grant is merely inadequate reporting, then there won't necessarily be requirements for recovering the money from the foreign grantee. So if the expenditure is taxable only because of a failure by the foundation grantor to make or obtain a full and complete report as required under these rules, then correction can be obtained just by getting the reports. In addition, if the expenditure is taxable only because of a failure to obtain full and complete reports as required, and the investigation indicates that no grant funds have actually been diverted to any use that is not a charitable use, then correction can be accomplished if all reasonable efforts are made to obtain the report and the service is notified of the failure. So there are special rules in the Treasury regs that cover all this. So that covered a lot of ground. I think the biggest takeaway for private foundation grantors making international grants is to make sure that you understand the various rules and that no grants go out the door without either an IRS determination letter for the grantee, a equivalency determination opinion letter, or a expenditure responsibility grant. These are all doable things. It just takes a lot more work than a domestic grant. So that's all for this episode. Be sure to check out the show notes for links to the resources I mentioned today. Also, Farella, Braun, and Martel has a YouTube channel, and the nonprofit playlists for the EO Radio Show podcast organize all of the past episodes to make it easy to find the information on the topics that are relevant to you. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun, and Martel. If you have suggestions for topics you would like us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.